I would like to formally welcome you to session 3 of this AI forum entitled Legal Considerations in Regulating the Use of AI Technology in Philippine Election Campaigns. I am Attorney Gian Rosales from the Office of Commissioner Nelson Celis, and I will be your assistant moderator. Let me introduce to you the moderator for this session. Attorney Froylin Pagayatan has specialized in corporate, taxation, commercial, and succession laws for more than 20 years. She is also a faculty member of the University of the Philippines College of Law. She is a regular speaker on taxation, commercial, and succession laws of the University of the Philippines Law Center, Paralegal Training Program, and Mandatory Continuing Learning and Education, or MCLE. At present, she is a Law Education Specialist 3 at the UP Law Center. Attorney Pagayatan finished her college education from St. Louis University with a degree in Political Science, magna cum laude, in 1996. She graduated from the University of the Philippines College of Law in the year 2000 and passed the bar and became a lawyer in 2001. Let us all welcome Attorney Pagayatan, your moderator for session 3.
Thank you very much, and welcome to everyone. It's quite a full room, right? So let's start by calling our speakers out to sit in front. So let's start with our first speaker. And our first speaker is Attorney Darwin Angeles. Attorney Angeles is a partner of Mosvelt Law. It's Mosvelldt Law. And he heads the intellectual property department of the law firm. His practice covers dispute resolution, data privacy, tech law. He is listed as a notable practitioner in dispute resolution by the Legal 500 Asia Pacific. He teaches intellectual property law at the University of the Philippines. He's also a guest lecturer for the IP Academy of the Philippine Intellectual Property Office and an accredited lecturer of the MCLE of the Supreme Court. Attorney Angeles is currently pursuing a Master of Laws degree, or have you finished it already? Finished na, all right. So he's now a Master of Laws finisher from Queen Mary University of London. Chevening scholar, correct? Yes. Congratulations, Attorney Angeles. And his studies, his Master of Laws, is with emphasis on the law on artificial intelligence and technology. So perfect resource speaker for our topic today. And of course, he obtained his law degree from UP 2013 with honors and holds a degree in chemistry from the Ateneo de Manila University, graduated in 2007. So Attorney Angeles, would you please kindly sit in front? Thank you. And then for our next speaker, well, he specifically requested that I forgo the quite long introduction prepared by Comelec and instead give this brief introduction. So our next speaker is Attorney Alberto C. Agra. He's law professor and bar reviewer for these subjects: election law, local government law, and administrative law. So he teaches in 4 law schools, for most of which is of course the University of the Philippines. Okay. And then, sorry. He's the author of Ballot Unboxed newsletter. It's free. It's readily available online, correct? He's a host of Batas et al. 2025 election series. How do we watch this, Attorney Agra? Social media. So if you want to know about all of these things pertaining to the elections, 2025 elections, what was said in the plenary session is the super election year, right? 2025. So it's on social media. He was a former government official, and he held these positions in government. He was acting Secretary of Justice, acting Solicitor General, and he's Government Corporate Counsel and Chairman of the Board of the Philippine Reclamation Authority. So ladies and gentlemen, please welcome Attorney Alberto Agra. Yes, sir. And our sole female is Attorney Ona Caritos. Attorney Ona Caritos is the Executive Director of Lente. She spearheaded policy and legal reform efforts as the Executive Director of Lente that resulted in the passage of the Election Service Reform Act, which provides public school teachers the choice on whether or not to serve as poll workers in elections. And also, as Executive Director, her work resulted in the policy which allowed the creation of accessible voting centers and separate polling places for indigenous peoples. On top of that, also her work resulted in the creation of an institutionalization of the Vulnerable Sectors Office in COMELEC. Also, the registration of website, web address, official blog, and social media page of candidates during the 2019 national and local elections. So on top of being executive director of Lente, she had also established so many groups, right? Like Bantay, Karapatan sa Halalan, Human Rights Desk, Task Force Election, and so on. So ladies and gentlemen, Attorney Caritos. Okay. And last but not the least, you also have Attorney Oliver Xavier Reyes. He's a senior lecturer of the UP College of Law and he teaches civil and criminal procedure as well as constitutional law 2 and public utilities law. So he teaches in other law schools and he also is one of the lecturers on data protection certification courses in the University of the Philippines Open University. Okay. He's currently a senior legal associate with the Technology Law and Policy Law program of the University of the Philippines Law Center. He is co-founder of the Internet Rights Advocacy Group, the democracy.net.ph, and had also been a writer at large for Esquire Philippines. Please welcome Attorney Oli Reyes. And we would like to acknowledge the presence of what Ma'am Malu earlier, the one Ma'am Malu acknowledged earlier as the what? Promoter? Originator of this forum, Commissioner Celis. Welcome, sir. Okay, so how are we going to go about this workshop session, this breakout session? We're going to have the speakers present first. And the first speaker to present will be Attorney Darwin, right? So Attorney Darwin came prepared with his presentation. Let's have his presentation be ready, please.
Okay.
While his presentation is being prepared, I'd like to get to know about our participants. So, who among our participants are from government, please? There you go. From the academe. So, professors or your students? Ma'am? You're both a teacher and a student. Also, very good. Law? Law school? Okay. Yeah, perfect. Okay. And then from civil rights groups, do we have representatives from civil rights groups? From PPCRV, correct? Okay. Anyone else who's coming from, one of the groups that I did not mention earlier? So government, then academia, civil rights groups, media. Is there anyone from media here? All right, I would imagine they'd be in session 2, right? Okay. And then law students. Do you have law students here? Wala. Okay, perfect. So Attorney Darwin's presentation is ready. So the floor is all yours, Attorney Darwin.
Thank you, Attorney Pagayatan. So, good afternoon, everyone. Thank you for having me today. And thank you to Commissioner Celis for organizing this and making this a reality, and to talk about a very important issue that's facing not just the Philippines, but actually the entire world. So next slide, please. Okay, next slide. Okay. So I've been asked to talk about key considerations on AI regulation, and I was asked by the organizers to at least give a brief overview of where does the world stand in relation to AI in elections, and what are they actively doing in minimizing the deleterious effects of AI in elections, as well as maximizing the benefits promised by artificial intelligence. So, um, we will be focusing on 5 examples as shown in the screen. So, we have the US, EU, India, Brazil, and I added the Munich AI Accord because I think this one is of a particular interest. Next slide, please. Okay. So, let's start with AI and the year 2024. Next slide. 2024 has been dubbed as the super election year. So it's like half of the democratic world is engaged in an electoral exercise. 2 billion voters, over 50 countries. France was added to the mix when Emmanuel Macron called for a snap election and they concluded it recently. And it was quite a whirlwind of a ride. Initially, it was the conservatives were going to win, and then it was the liberals. But you also have various jurisdictions, both from the global north and the global south. So the Philippines is currently facing, preparing for the 2025 elections. And the same problems encountered by these countries are the same problems that we will also face. And we have this unique benefit that we can learn from their experience. And I hope this is what we can maximize in this session. Next slide, please. Okay. So I have a few examples of some elections that were conducted earlier this year. So, for example, in Indonesia, the use of AI as soft fakes was noted in the rebranding or the successful rebranding of the former defense minister, I may be mispronouncing his name, Prabowo Subianto, by appealing to the younger Gen Z generation as an ideal candidate. And this translated into an overwhelming election victory. Next slide, please. In Pakistan, the jailed former Prime Minister Imran Khan, he was accused of various offenses, terrorism, leaking state secrets, among others. And his party was prohibited from campaigning during the elections. They were able to campaign literally from jail and still able to win 100 out of the 265 contested seats in their parliament, thanks to AI. And this is, I believe, a deep fake of Mr. Imran Khan delivering a victory speech to his supporters, thanking them for their support in the recently concluded electoral exercise. Next slide, please. I mentioned France earlier. It was noted during the snap elections that all parties were using AI for voter engagement. So they used it to amplify their message. They used it to criticize the other candidates. So for example, right-wing parties, the perceived dominant force who wanted to take a majority in the French parliament used generative AI to convey messages of anti-immigration, lack of safety in France, lack of freedom of expression, while at the same time maintaining a centrist image because there was the right-wing party in France has long been associated with controversial views. So they were the AI helped them become more palatable to a younger electorate, similar to what Prabowo Subianto did. But nevertheless, despite the initial success during the first round, during the runoff elections, a united leftist coalition with the current Macron's party were able to stave off them winning an overwhelming majority in parliament. Next slide, please. And then some observations in Africa. I included Africa because I had the great pleasure of engaging some academics and scholars while I was in the United Kingdom. And we were talking about these issues. As a side note, when I was doing my Master of Laws in the UK, we had a subject called AI regulation. And it was bit of a meme of a subject because all of the regulations that we're discussing right now were not even in existence when we're doing that subject. So literally the entire world was learning how to do AI regulation with us. But there are some notable examples in how they deployed the technology or how government flexed its muscle to enable AI's responsible use in elections. So, for example, AI has been used to improve voter registration and verification processes using biometrics. So they were able to eliminate fly voting in delinquent areas. They used AI to enhance cybersecurity by being able to analyze real-time data, identify where cyber threats are coming from, and take immediate action to address the same. And then chatbots and videos of AI were deployed to help the electorate gain valuable information on how to come out during election day, where they can vote, how they can report problems, and so on and so forth. So I think when we go to a session about AI, it's common to hear about the problems associated with AI. It's perceived that AI is an existential threat to democracy as such. I do agree with that, yes. But the recent examples are encouraging because there is a way with the cooperation of regulators, the private sector, and of course, a very well-informed citizenry to leverage and use AI as the tool that it was envisioned to be. Next slide, please. So I will keep my presentation short. That was the first part of my presentation. Let's focus on some emerging regulatory frameworks for AI. Okay? And next slide, please. Let's start with the United States. The United States is interesting because they do not have a framework for AI regulation. So you might be wondering, why are they here, attorney? Because the US, as we know, is much of our laws are patterned after them, and a lot of the AI companies, the big data companies, are headquartered in the US. So one of the problems in regulating AI is the territoriality aspect. How can we expect them to obey orders of governments when they are headquartered in a foreign jurisdiction? There's that consideration. And they can invoke the laws of their home jurisdiction to repel claims of liability. And for that, I call attention to at least two key pieces of legislation, or rather, one is the Constitution, the First Amendment, freedom of speech. AI content in the US is viewed as speech and enjoys constitutional protection. And any attempt to regulate AI may be seen or can be challenged as prior restraint and therefore unconstitutional. And then this is doubled down by Section 30 of the Communications Decency Act, a law that is not recent. This was enacted in 1996. So it was a law that came with the emergence of the internet. It was this law, it essentially grants immunity to an internet service provider or a platform for content that is posted on its website or platform. So this is the law that Facebook can invoke to say that the deepfake, the porn video that's posted on its website, they're not responsible for it. If you want to take it down, you get a court order against the malfactor. Tell them that you're able to get a court order to take it down. Until then, they can do nothing, and the law of their jurisdiction allows it. Federally, this has created a bit of a quandary because there is no AI regulation on AI. And I noted recently, last month, the Federal Communications Commission tried to impose a regulation on how using it's a equivalent of the Philippine National Telecommunications Commission. So they tried to impose a requirement that ahead of the 2024 national elections there, if politicians are going to use AI, they have to disclose that they're using AI in their TV and radio ads. This was unfortunately, for reasons beyond my knowledge, because I'm not an expert in their laws, was opposed by the Federal Election Commission, claiming that it is their authority to do so, and therefore any kind of regulation on that aspect must come from them. Okay? Next slide, please. But that's not to say that AI is totally untouched in the US. On the state level, there are actually laws enacted already to address certain use cases of AI, particularly deepfakes. So, um, at least 30 states have pending bills in their state legislatures to regulate the use of deepfakes. And there are at least 6 states, as of my preparation of this presentation. I did a quick survey the other night. And I've identified California, Texas, Minnesota, Michigan, New Mexico, and New Hampshire to have laws that either criminalize the wrongful use of deepfakes, a very narrowly tailored legislation. It's worded in the what they criminalize is the use of deepfakes with the intent to commit fraud or to depict a false action by a person. So it's like falsification. Okay. Some state laws require campaigns to disclose the use of AI content. So they either put a watermark on the deepfake or on the content, or there is metadata in the content that can allow for traceback as to who is the origin or what is the origin of this AI content. And then there is a remedy. The aggrieved candidates can file for an injunction against violations. So uh, it is expected that perhaps some of the pending bills pending before the state legislatures will ripen into legislation to prepare for the 2024 national elections. And this looks like how they're handling AI in the continent, at least in the United States. Next slide, please. In Europe, they just came out with this very important piece of legislation, the AI Act. So this one has been it's been languishing in European Parliament for years. I think they started this in 2019, 2020. The pandemic intervened, and it has gone through cycles of legislative refinement. In fact, just last year, I remember I wrote a paper on this as one of my final requirements. Um, August 2023, there were still 2 versions of the AI Act that was being discussed by the European Parliament, and they had to reconcile these 2 versions to come up with the final product. Now, my presentation will not go into the nitty-gritty of the AI Act. The text itself is already like 400, 500 pages long, and it will require a mini course to master it. But allow me to at least go through the index of the Act, tell you what does this mean for AI in general. So the Europe's approach for AI through the AI Act is similar to the regulation that they had for the GDPR, the General Data Protection Regulation. And that's the same law after which our Data Privacy Act was patterned after. So it's a law that maintains standards. So here they classified AI systems. They identified prohibited use cases, outrightly illegal. I'll go into it later. High risk systems. So AI systems that have the potential to be misused for unlawful ends, but have, for the large part, very lawful use cases. And general purpose AI models, there's 2 subcategories here. There's limited risk models and no risk models. So these are subjected to less stringent regulation. Okay, and then the Act has measures in support of innovation. Why do they have that? Because AI now is also a factor in geopolitics. The US, part of the reason why the US does not have a federal regulation against AI or governing AI is because they want Silicon Valley to continue pushing the envelope with respect to AI. Why? Because across the Pacific Ocean, you have China. And China wants to become a leader in AI as well. So any attempt to regulate AI is seen as an attempt or is seen as a damper against innovation. Okay? So Europe is also doing the same. but they are introducing a regulation. So to mitigate the impact of the regulation, we'll say, okay, if you're compliant, you are qualified for these incentives. The the AI Act also establishes a central AI board under the jurisdiction of the European Parliament, and it will be based. Well, they don't have a site yet, but presumably in Brussels. But it will have national authorities. So the there will it's akin to establishing data privacy authorities in every jurisdiction whose job is to police AI on a per EU state level. And then you have post-market monitoring. Post-market monitoring is it's an obligation on the part of the AI operator. So they they are given obligations that they must ensure that their clients are adhering to the terms of service of the AI systems. Because the terms of use on an AI system is actually the first level of regulation on against misuse. Because misuse means that you are violating the terms of use. Because conceptually, an AI, a law-abiding AI owner will not release a product within and grant people the authority to commit fraud, to create deepfakes, to create porn videos with it and the like. So the in the exercise of post-market monitoring, the rationale is that the EU forces the company to strictly enforce the terms of use with their clients. And then you have post-market surveillance. That's the state aspect that is done through the national authorities. And then you have other provisions. Next slide, please. Okay, so I think I went through this at length, so you can skip this. Next slide, please. Okay. Well, there are standards for compliance for the low-risk models for GPAI. The thing with the AI Act, it's still not yet enforced. So I think what they're doing is translating the document into all of the national languages of the EU. And it will come into force once it's published in the Journal of the European Union, which was originally scheduled in May or June of 2024, but now has been pushed back to the end of July. Hopefully it gets published. But the consequence of that is there are certain standards that they are putting forth that companies must comply on a self-regulatory basis, and that come into force within a certain set of time, within a certain period of time from the time the AI Act enters into force. Okay. In the meantime, the law provides for a stopgap measure. The companies may enact a code of practice. So they will undertake obligations on their part. We will not do this, and that will be considered as compliance with the AI Act. And then you have the EU AI Office. I think they discussed this already. Next slide, please. EU-wide governance. So to give more teeth to the monitoring and market surveillance measures, they have a way of registering, similar to how you register a data system in the Data Privacy Act or their GDPR, so that they can keep tabs on the legitimate AI systems. And that they can, if there is a problem with respect to that AI system, they can definitely go after whoever is operating it. Okay. And then if it's and then it can, well, this is me rushing, but if it's presumably not registered, then it can be considered as an illegal system. Next slide, please. Okay. India right now doesn't have a an AI law similar to the EU, but they have a counterpart of the COMELEC, and they just recently concluded their elections, I believe last March or April, and at that time there was an interesting reaction from their electoral authority when an AI system was asked, is Modi a fascist? Modi was the leading candidate for the ruling party there, a favorite to win prime minister, and he got re-elected actually. So And the AI system responded in a way that the government, since he was the incumbent at that time, did not like. So they initially came out with an advisory saying that tech companies must obtain government approval for AI systems. But they realized that such a requirement, again, with AI development being an important key economic consideration, would be a dampener to their burgeoning digital industry. The Indian authorities withdrew that requirement 2 days later, and they just said that AI should be made available to Indian users only after appropriately labeling the possible inherent fallibility or unreliability of the output generated. Next slide, please. Okay. In the other American continent, in South America, Brazil has an interesting approach to AI. So they're actually they're 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 actively pushing for their own AI Act, which they hope will be the alternative or counterpart to the EU's AI Act, which some jurisdictions might find as too intrusive into business. But those bills have yet to be enacted by the Brazilian legislature. In the meantime, since they also have a counterpart of the COMELEC there, which is part of the judiciary, the Superior Electoral Court came up with 12 judicial resolutions regulating the use of AI to ensure integrity of elections. And among the key regulations laid down are, well, we discussed some already, an indication that content made by AI should be labeled as such, prohibiting the use of AI to create disinformation. Next slide, please. Gatekeeper liability for failing to prevent or reduce the circulation of AI content that can taint the integrity of elections. This is important because a lot of AI system, gatekeeper liability is a key consideration in policing AI, because if there is no liability for gatekeepers, the main mechanism for enforcing or enforcing redress is their self or voluntary undertakings that they will do so or enforce their terms of use. And to finish Brazil, they lay down limits to sponsored promotion, prohibition against false, misleading, harmful, derogatory content, and so on and so forth. These are translations from the Brazilian text, and I consulted my friend from Brazil, and I hope it's pretty much accurate. Next slide, please. Okay. The last one, the Munich AI Accord. In February 2024, at the Munich Security Conference, this was a very big international conference attended by representatives from big data, and when the topic of AI was discussed, they came to an accord as to a code of conduct voluntarily undertaken by them as to what acts they will promote or what activities they will refrain from doing. Okay? So, especially with respect to the creation of deceptive AI election content, which is why I quoted the definition here, because they crafted a very narrow definition of deceptive AI election content already, so that the scope of these undertakings are already very narrow. So all other use cases not election related will not be affected by this. Next slide, please. Okay. So what have the tech companies undertaken? Developing and implementing technology to mitigate risks related to deceptive AI election content. So these are the same measures that other jurisdictions are also considering. So it's reinforcing the trends that you are seeing in other countries. Or on the flip side, the other countries are also adopting this measure as part of their regulations. Assessing models in scope of this accord to understand the risks they may present regarding deceptive AI election content. So it's essentially an internal mechanism to train depending on how you create your AI, whether it's large language modeling, you vector analysis or something. Try tweaking the system to avoid its misuse for creating deceptive election content or to allow detectability when it's being used in such an illegal manner. Seeking to detect the distribution of deceptive AI election content as hosted on their platform. So this is on the enforcement side, because the harm with disinformation and harmful election AI content is that once it's gone out, It might be taken down like a week later, maybe a month later, but the damage could have been done. Because the primary reason why you'll go engage in these kinds of activities is you'll release a deep fake right in the eve of the elections and change the minds of last minute voters. So the goal here is not to just give an enforceable mechanism, but a very rapid reaction mechanism to take, well, at least take enforcement action against illegal content. Next slide, please. Seeking to appropriately address deceptive AI election content we detect in a manner consistent with principles of free expression and safety. Now, I highlight this last clause, in a manner consistent with principles of free expression and safety, because it means that you have the First Amendment analysis relevant here. Just because something is apparently, well, one side may say it's illegal, but it's subject to interpretation. So they may choose to not take action if they believe that the posting of what people call deceptive election AI content is an exercise of political rights. Okay? Because in elections, in the exercise of political rights, sometimes things can get very heated, very passion, right? And that's the challenge of the COMELEC. They have to maintain a balance of discourse. And finding the sweet spot is really the challenge. It's also the same problem encountered by the tech companies. Fostering cross-industry resilience to deceptive AI election content. So it's essentially a sharing of practices so that nobody has a monopoly and people can get to identifying the sweet spot faster. Transparency, continuing to engage with the diverse set, it's really to spread the knowledge, to improve the processes that they have sooner, faster, so that you avoid creating or at least impacting serious irreversible harm because of AI. Okay? So I think this is my last slide. Next slide, please. So this concludes my presentation, everyone. So I hope this was helpful. There are other jurisdictions that are not included here, but I hope that the 5 that I've cherry-picked were very helpful. And if you have any questions, I'll be available to answer them later. Thank you.
All right. Thank you so much, Attorney Darwin. So, for your questions, hold your horses. We're going to have to ask all of our speakers to give their presentations first. And if you want to hold on to your questions, maybe write it down. Remember the small, cute notebook that Ma'am Malumanga showed earlier? I hope you all got that. I didn't get one. But if you have questions, please, maybe you could write it down on your cute notebook so that you can ask them later on. So you won't forget about your questions. Okay. So thank you so much again, Attorney Darwin. You brought us around the world, right? You gave us a glimpse of how AI is treated, is sort of regulated in these other countries. So you started with an acknowledgement that at least in 2024, AI had in fact been used in election campaigns. And in fact, AI had been shown to have influenced election results in some countries, right? And you also stated that while it seems there's this fear of AI, you also stated that, look, there's a way to leverage AI. There's a way to use AI in order to, improve our electoral processes. And then you mentioned about the United States of America. You said that at least on a federal level, there's no regulation yet of AI. And you said that one of the reasons could be the fact that AI has become a factor of geopolitics. So apparently there's this competition, right? Apparent competition between the United States and China. So regulating AI, at least on a federal level, could dampen innovation. But on the states level, you stated that there are already 6 states in the United States that have passed laws that regulate AI. Specifically, these states criminalize the wrongful use of deep fakes. In your presentation, you even talked about soft fakes. That was the first time I've heard of soft fakes. So maybe later on you could expound on what is soft fakes and what's the difference between soft fakes and deep fakes. And then also, among the 6 states in the United States of America that have passed laws with respect to AI, they have provisions that require the disclosure of the use of AI content. And then there are also injunctive remedies, right, in these laws. And then you brought us to EU, and you talked about the EU AI Act. And you said that in the EU's AI Act, right, they have post-market monitoring and surveillance, where there's emphasis on compliance by tech companies with the AI terms of use. And in the AI Act of EU, there's even a requirement for tech companies to register the AI technology, right, that they use. But what I got with respect to the provisions in the AI Act on standards on companies is right now, it's still basically self-regulatory, right? Because they haven't come up yet with standards. So it's basically self-regulatory at this stage. Okay, and then you brought us to India, and you said also India does not yet have AI laws. And then for Brazil, it's a different story. Because they have, they're pushing for an AI Act, but in the meantime, the COMELEC counterpart in Brazil has already passed 12 resolutions, right, pertaining to the regulation of AI-generated elections content. And in Brazil, they have gatekeeper liability, which is different in the United States of America, because in the United States of America, they have a law that provides gatekeeper immunity, right? Where these gatekeepers, these tech companies, are actually immune from liability with respect to content created by third parties as well as their users. And finally, you talked about the Munich AI Accord. And you said in this Munich AI Accord, there was a definition of what is deceptive AI election content. So it may be something that we can look at and perhaps copy with respect to the main objective why we're having this now, which is to give input to the COMELEC with respect to the resolution, with respect to the frameworks that they would like to enact pertaining to the use of AI in the elections. Okay, so again, thank you, Attorney Darwin. Next, okay, let us hear from Attorney Agra.
Magandang hapon po sa ating lahat, fellow lawyers, fellow election law learners. Commissioner Celis, maraming salamat po. To my friends in COMELEC, nandyan pa po kayo hanggang ngayon. At the topic is about legal considerations, about AI, social media. For my purposes, my discussion will just be about the COMELEC. The authority or lack of authority of the Commission on Election to regulate, to regulate social media and to impose sanctions. If you recall, and this was cited earlier this morning, that the COMELEC resolution then, the general perception of lawyers and members of the teaching profession, they felt that the regulation then had no teeth. So, question is, magkakaroon ba sana ng IPEN? Hopefully magkaroon ng IPEN this coming election. So, I took it upon myself to discuss the authority of COMELEC. So, ang tanong lang naman is, pwede ba or hindi pwede? Can or cannot? And of course, there are only two ways of looking at the authority of, and the breadth and scope of an authority of an administrative agency like the Commission on Election. Ang pagtingin ba natin ay centrist, myopic, narrow view? Or are we going to take up the liberal or expansive, broad view of powers of the Commission on Election. Let me explain the centrist view. Kung anong binigay sa'yo, yun lang ang pwede mong gawin. Okay? Ano yung liberal view? Basta hindi bawal, pwede. Okay? Kung hindi bawal, pwede, at kung makakatulong sa publiko and in pursuance of your mandate, then why not? For this afternoon, I will take the liberal view. Okay? So, if you want me to take the centrist view, mamaya po, pwede kong gawin yun as an academic. But for now, I'd like to help COMELEC strengthen its legal basis for taking a proactive stance in terms of social media. And let me commend the COMELEC for doing that. Okay. Is COMELEC the same type of admin agency as other admin agencies? No. Because the reason why COMELEC is different from other admin agencies, because COMELEC is created under the Constitution, as we all know. And therefore, the Charter of COMELEC is not just an act of Congress. The Charter of COMELEC is the 1987 Constitution. Unlike the Department of Justice or by former office, the Philippine Reclamation Authority, these are all created by law or by statute or even by executive order. So iba po ang Commission on Election. So let me, okay? So, broad authority of COMELEC, no? Mnemonic. I don't know, to my former students, so you know, do you still recall this? CHEOFE. The mandate of COMELEC is to ensure clean, honest, orderly, peaceful, free election. So kung merong deepfake, kung merong misinformation, how can that be free? How can that be orderly? How can that be peaceful? And as highlighted earlier, as we all know, COMELEC has the power, obligation to enforce and administer all laws, power to promulgate rules. By the way, in class, I always say that COMELEC is one of few administrative agencies that has the power to issue the 6 types of rules. No? And very important when we talk about social media is, can COMELEC define offenses? Of course not. Can COMELEC impose penalties? Of course not. But the exception is, and this is where I'm headed, is if there are laws which empower COMELEC to issue rules and provide penalties for these rules, then COMELEC can issue these penal rules. There must be a strong, clear statutory mandate, which I will explain when we talk about the specific authority. And, of course, it has autonomy, which is not given to all other admin agencies. The autonomy to adopt measures to ensure CHEOFE. Okay? Let's now talk about the specific authority. By the way, I only have one slide for my portion. Omnibus Election Code became law 1985. Hindi pa po ako abogado noon. And even that law, for me, lays down the basis for COMELEC's authority today to regulate social media and impose sanctions. When the Omnibus Election Code says that COMELEC has the power to prescribe the use or adoption of latest technological and electronic devices. So when it says latest, that includes internet or social media, taking into account the situation prevailing. So not just the situation in 1985, but the situation prevailing today. So that's legal basis number 1. Legal basis number 2, under the same Omnibus Election Act, COMELEC is duty-bound to stop any illegal election activity. No? Not just regulate, but to stop any unlawful, libelous, misleading, or false election propaganda, like deepfakes, no? As we have discussed earlier. Number 3, and there are just 6. Number 3, under the Omnibus Election Code, it has the power to regulate regulate mass media, which, broad definition, mass media could include social media. So that, yeah. And, by the way, that provision under the Omnibus Election Code, I don't know if you all know, can be a ground to disqualify a candidate under Section 86. So it is one of the enumerated election offenses that the candidate, if he or she violates that, can be disqualified. But as you all know, kandidato ka lang pagdating ng campaign period. No? Wala tayong kandidato sa Pasko. I think that's one of the things that has to be reformed. We have no candidates till the campaign period and therefore walang vote buying sa October 9. No? Walang premature campaigning sa October 10. Because there are no candidates at that time. February pa at March tayo merong kandidato. Kaya expect a lot of greetings in social media. Ingat sa biyahe. Happy Fiesta, Happy Halloween, Happy Graduation, I love you, pag-ibig, kung pinag-usapan kanina. So, are those election campaign materials? No such thing before you become a candidate. No? So, ang tawag doon, those who will file October 1 to 8, ang tawag ko sa kanila, aspirants, filers, candidates in waiting, dreamers. So, if they commit any of this regarding regulating mass media, then they can be disqualified. Of course, they have to commit it during the campaign period. Under the Fair Election Act, there was also mentioned earlier this morning, maliwanag na bona fide candidates shall be free from any form of harassment and discrimination. And of course, deepfake is a form of harassment and discrimination. And very clear, very important for us to note, COMELEC can issue rules pertaining to the implementation of the Fair Election Act, and any violation of the COMELEC rules is considered an election offense. So that is a clear authority given to COMELEC to issue penal rules. There's a discussion, a proposal, I don't know if this has been approved by the COMELEC and Bank, to post and share yung mga certificates of candidacy. Ang aking lang warning doon, wag pati yung signature. Kasi baka lumabag sa Data Privacy Act. Everything else, I think, can be shared. No? So, and lastly, regarding cyber libel, using fictitious name, concealing true name, intriguing against honor, unlawful means of publication, under the revised penal code, these are crimes and the cyber law. So, COMELEC can assist in the prosecution of these offenses. So let me end by saying that please, COMELEC, do what you have to do. By not regulating social media, you might be remiss in your obligation to protect everyone from misinformation and disinformation. Yun lamang po. Maraming salamat. Magandang hapon sa ating lahat.
Okay.
Ba't ako lang nandito?
That's what I was asking also. I guess the other speakers wanted to sit out here in front so they could see the marvelous presentation of Attorney Agra.
And
All
sorry,
right.
one more konting advertisement. I have this Ballot Unbox newsletter. So if you want to subscribe, just log on to my website, albertociagra.com. Every Thursday, you'll get my newsletter for free. Again, this is my advocacy for continuing education. I believe in election law for all, local government law for all. Yun lamang po at sorry sa advertisement.
Okay,
At wala po akong balak tumakbo. So, thank you.
perfect. So speaking of advocacies, I think you've been given those sheets of paper where you're supposed to write your pledges. What pledge? Not pledge of love or pledge of whatever dream you have. Pledge for a clean, honest, orderly elections. And after this session, when we go downstairs for the plenary session, for the reports, you may post those pledges on the tarp downstairs. Correct? It's downstairs, right? Okay. So thank you so much, Attorney Agra, again. So it seems like this afternoon is all about views. Attorney Darwin here gave us the worldwide view, but Attorney Agra gave us the what? Liberal view. And Attorney Agra, well, sort of encouraged the COMELEC that, look, you actually have all of these laws we have now in the Philippines that you can use in order to regulate artificial intelligence, or as what the topic of Attorney Agra is, social media. Okay. And so let us hear from the perspective of Lente, represented by Attorney Ona.
I will try to present for 15 minutes or less. Kasi alam niyo po, the spring does not rise higher than the source. Tanungin niyo po ako bakit may ganun akong saying. Legal maxim. But, grabe naman kayo, parang di kayo gising. The spring does not rise higher than the source. Bakit kaya? So I'll try to present in 15 minutes or less because Attorney Agra was my teacher in election law 2 years ago na. 3 years ago, sir. So, I will try to present 15 minutes or less. Okay, magandang hapon po sa ating lahat. I'm Attorney Ona from Lente, and I will be presenting our recommendation to COMELEC on how to deal with this problem of AI and disinformation. I am with Attorney Helen, and alam ko teacher rin po kayo ni Helen, sir, sa Ateneo. So kami po ay mga padawans ni Attorney Agra. Padawan. Okay, so the title of my presentation this afternoon is It's a Balanced Approach to Artificial Intelligence for the 2025 elections, and we're proposing ethical guidelines, transparency approaches, and political education to address this problem, or actually to address this challenge of the use of artificial intelligence in our elections. And the scope of my presentation for the next 15 minutes is, let me just, di ba may kasabihan po tayo, dapat lumingin tayo sa pinanggalingan para makarating sa, gabi, hindi po talaga yata ako yun, para makarating sa, so we need to familiarize ourselves again on our problem of disinformation since 2016. The 2016 presidential election was labeled by a lot of stakeholders as our first social media election. So, and we started encountering this problem of fake news, disinformation in this election. So, I want to show you at the start of this presentation how this problem of disinformation has evolved through the years and how the solution nagbi-blink siya. Bakit kaya siya? Sorry. The second part of my presentation is just like Attorney Angeles, Attorney Darwin, I will be presenting, and I will not be discussing some of the experiences already discussed by Attorney Darwin, but we'll be presenting some approaches of other jurisdictions all over the world to address this challenge of misinformation, the use of AI in elections, how AI is used in elections globally, and what we anticipate AI would be used for the 2025 national, local, and BARM parliamentary elections. And lastly, I will end with our recommendations for duty bearers and for other election stakeholders. Pakilala ko lang po yung LENTE. It stands for Legal Network for Truthful Elections. We are a civil society organization. We are an election monitoring organization. And we are an electoral reformer. So we do election monitoring, but it's purposive and systematic. I see Director Mona here, and yesterday kamiting lang po namin si Director Mona to talk about accessibility in our election. So ganun po magtrabaho ang LENTE. We're looking at specific aspects of our elections and proposing policy changes within COMELEC and with Congress to improve our elections, our future elections. Ay, nag-upgrade yung system. Very good naman yung system na to, nag-upgrade. Kasi ganyan po ang AI, nag-evolve. Ang bilis na evolution. Kahit po yung TV, nag-evolve agad. Okay. So, habang nag-upgrade yung system natin, do you want me to pause? Yeah. Mhm. Pero yung TV ata yung yung TV yung nag-upgrade, postpone na lang yung sa TV. TV siya. Ha? Attorney Jane? Ayan, mag-upgrade na siya. Sandali lang po AI is listening to us. Turn on. Okay. Pwede ko i-share? Oh, pasensya na po talaga. Sana hindi po counted sa 15 minutes ko tong technical difficulties. Sige, Helen. Doon tayo sa slide on yung evolution. Percent. Okay, sige. Ayan. So next slide. So this is the evolution of disinformation in the Philippines. And just like what I told you earlier, our problem with fake news, disinformation started 2016. Just like what I mentioned earlier, the 2016 election was labeled as our first social media election. And this is when we encountered the problem of fake news, disinformation. At dito po natin unang na-encounter yung mga trolls at bots. Dito po tayo nagkaroon ng problema with anonymous accounts. And then 2019 elections came along, the midterm elections. And hindi na po trolls and bots yung naging problema natin in the 2019 elections. It became the influencers. Yung influencer na po yung naging problema natin, yung disinformation innovation. And it started, we saw the use of influencers in our elections. But from the use of influencers, 2022, mas naging targeted na yung influence operations. Now we have communities. May mga pages na dedicated solely to supporting a candidate. May mga pages created solely to discrediting or maligning, spreading disinformation against certain candidates. And actually, ito po yung mahirap nung 2022 because people now have their own version of what is true. They have their own silos of truth. So yun po yung problema nun. So 2016, it started with bots, trolls. May question pa or may debate ba on what is true and what was not true. But 2022, people had their different versions of what is true or what is truthful. So that was our hard problem in the last major election or the last 2022 national local elections. And we're looking at 2025. Are we looking at an AI-enabled disinformation And that has been the actually concern. Para magkakaroon na ba tayo ng Terminator sa election? Diba that's the concern for next year. Will we see AI use in disinformation, especially in the Philippine national and local elections? Next slide. And we did a study on the different approaches jurisdictions adopted to address problem of disinformation in their respective jurisdictions. And there are 4 approaches. One is criminal sanctions for spreading disinformation. And na-discuss naman to ni Attorney Darwin and Attorney Agra. Second is transparency initiatives to improve perception of accountability in an election. Third approach is regulation of monitoring. Regulation or monitoring of social media. And the last one is, and we are all familiar with this, hindi ko po alam kung kayo ay naging parte nito, who are fact checkers inside the room or who were trained to fact check. We have actually 3 major fact checking organizations in the Philippines. Andiyan ang Rappler, Beta Files, IFCN. So those are the 4 approaches tackling or combating disinformation. 4 major approaches that we saw when we studied 33 countries and their approach regarding disinformation. Next slide. And ito po, sobrang interesting na slide. These are the bills filed in previous years to combat disinformation. Bills filed on disinformation. 10 minutes. If you take a look at this slide, color-coded siya, you can actually see when elections are about to happen. For example, 2016, isang bill lang yung final on disinformation. 2017, isang bill lang din on disinformation. But 2019, the year of the elections, several bills were filed on disinformation. 1, 2, 3, 4, 5, 6, 7, 8. So 8 bills were filed on disinformation. And if you take a look at these different bills, you will see that the solution would always be related to the problem that we encountered in the previous election. For example, on Online and Social Media Membership Accountability Act, HB number 715, it was filed before the 2019 midterm election. Remember what was our problem in the 2016 elections? Ano po yung problema natin ng 2016? Anonymous accounts, trolls. Kaya ang final sa Congress natin, Online and Social Media Membership Accountability Act. Our Congress wanted users of social media platforms to submit identification to prevent trolls and anonymous accounts. But remember, our problem evolved from trolls to disinformation innovations. So our Congress was looking at a solution particular to the previous election, pero that solution was no longer applicable or important to the problem that we had in the 2019 elections. Bakit ko po binibelabor yung point na yon? Just to emphasize that, katulad po na nabanggit ni Chair Garcia at ni Chancy Vistan, ang bilis talaga ng problema natin on disinformation. And yung policy, dapat siya flexible enough to address this evolving problem. Okay, next slide. We had an event a few months ago, and we wanted to tackle AI use in elections, so drawing insights from global perspective. So this event, we brought together 100 election management bodies, experts, policymakers all over Asia to discuss and learn from the elections that happened this year. So the world is in a super election year. The Philippines will have its own version of super election next year. At yun nga pa yung sinasabi nila Comcelis earlier. And yung global trend po talaga this year, what we see and what we are seeing in the elections, this super election here is the increasing influence of video or deepfakes. And we saw this in the 2024 Taiwan and Indonesian elections. And later I would expound on how deepfakes were used in these two Asian neighboring countries. So ginamit po talaga sa Indonesia at Taiwan ng deepfakes to influence the elections. And in the discussions that we did in this forum, it was identified, and ano naman po to, para talagang di tayo papunta, election misinformation and disinformation is really one of our threats in the elections next year. And it's important to maintain election integrity and transparency in elections. It was agreed upon by the different stakeholders. Siguro po, labas lang si COMELEC kasi may ibang perspective din si COMELEC that it's better to have transparency initiatives. It's better to have media and literacy initiatives rather than prioritizing prosecution. And it was emphasized by Attorney Darwin in his presentation earlier na mahirap ang prosecution in some jurisdictions, especially if the regulation or the prosecution would be used against certain individuals running in the elections. Next slide. So ito po yung mga nakita na use ng AI all over the elections this year. In India, ginamit po yung AI. So they use AI for their campaigning. Kasi mabilis lang siya, hindi ganun kamahal. So they use in the Indian elections AI constructively. In Indonesia, katulad po na nabanggit ni Attorney Darwin, it was used by the winning candidate to make himself appealable to the young generation. Gumamit po siya ng mga avatar, chibi, to appeal to the young generation. And in Taiwan, what they saw was the use of AI, especially in foreign intervention. AI was heavily used in foreign intervention in their elections. It's Taiwan and China. So AI was used along that lines of intervention by China in their elections. But the key feature in Taiwan, although AI was a big problem, the coordination, the strong coordination between civil society, election management body, and private sector, and ang active engagements with social media platforms. So despite the problem with AI and foreign intervention or influence, the key feature of the Taiwan elections was the strong coordination with the different stakeholders. Next slide. And nabanggit na po ito ni Attorney Darwin na these are the different documents that we could reference when we talk about AI regulation. It started with the UNESCO recommendation on the ethics of artificial intelligence. And we have the world's first AI law, the EU, European Union AI Act. Thank you. Next slide. And if we look to our neighboring country, which just had their election, our Indonesian neighbor, their Ministry on Information, they issued a document on AI ethics guidelines. So, etong document na to was to provide ethical guidelines to business actors engaging in business activities on AI use or AI-based programming activities. But this was a normative document. Normative document, ibig sabihin, it wanted to influence the behavior, but there's no punishment, there's no punitive provision in this document. So it just provided ethical guidelines on the use of AI. Next slide. And in the Philippines, we also have working documents on the use of AI. Sa DTI po, naglabas na yung National AI Strategy Roadmap. Naglabas na din po ang DOST, and recently, COMELEC inked or signed a MOA with NBI on combating deepfakes and combating cyberbullying in elections. So yan po yung mga recent developments in the Philippines on frameworks and policies on AI. Next slide. And in our 19th Congress, if you take a look at the different bills filed, there are 9 House bills filed on artificial intelligence. And out of these 9 bills, isa lang po yung nagtatouch upon deepfakes in election. And it made deepfakes, the use of deepfakes in elections as an election offense. So out of these 9 bills. But if you would ask me, saan papunta itong mga bills na to, Medyo malabo na po ito mapasa kasi it's an election year and most of our legislator, most of our members of Congress will be out to campaign in their respective districts, or our senators would be out campaigning all over the country. But this is the current situation right now in Congress as to the use of AI and the bills filed regarding it. Next slide. I would also want to talk about paano nagre-respond yung platforms. And let's talk about Meta. So Meta uses 3 approaches to address disinformation and use of AI. One is you need to disclose AI use. So there's an AI content disclosure. So if you use AI and you are a creator, you need to disclose that you use AI. So may mga labels po, if you take a look, AI generated, altered, or synthetic content. So that's one approach of Meta. Another approach is content labeling. And this has been used in previous elections. For example, noong 2022 po, may content labeling on the case of Marcos versus yung sa case po ni BBM. And this was labeled as fraud. This was labeled as not true. So may ganun din pong approach or initiative si Meta. And lastly, may policy enforcement through platforms community guidelines. So if you violate the standards of Meta, then your post would be taken down. Next slide. So our stand on actually at first, COMELEC issued out a strong statement banning AI in the use of elections. When it was discussed a few months ago, pero buti na lang po, nagbago rin ng position si COMELEC because when COMELEC came out with that strong position, our stand was to push for transparency and less draconian measures because we recognize that it's really hard to actually prohibit the use of AI in elections, given how it has also been used in other sectors or industry, and naihirapan yung ibang sectors and industries to also regulate the use of AI. So, next slide. I only have 2 minutes. Bilisan na lang po natin. Next slide. So what do we propose COMELEC to do for election information integrity and transparency? One, we're always proposing that COMELEC has a rigorous and systematic social media monitoring. And to do this, we're really pushing for COMELEC to have its own social media unit. And to do that, we're lobbying for additional budget on the part of our election management body. Because there's really a need for our Commission on Elections to have their own monitoring unit to monitor what's happening in the social media spaces. And another recommendation to COMELEC is to focus on transparency approaches over content regulation. And to do this, we are proposing that there's a need to operationalize Section 7 of the Fair Election Act and COMELEC space and time. Again, this entails additional budget on the part of COMELEC. And if there's additional budget for these 2 sections, it would improve the transparency of our election. And at the same time, it would level the playing field amongst candidates. Next slide. So what do we recommend to COMELEC in collaboration or in partnership with tech companies? First recommendation is to engage with social media companies, and we're really happy that Commissioner Celis, his office, the Task Force KKK, is taking the lead on creating partnerships and engaging with the different online media platforms. Second recommendation is to engage with other relevant government agencies because there is a need outside of COMELEC to engage and to partner with other government agencies which have the expertise on monitoring, like NBI, DICT on monitoring AI, and the creation actually of guidelines on AI use in the elections. So we're recommending DTI, DICT, DOST on the possible government agencies that they can tap to regulate or to partner or collaborate with with other election stakeholders. Next slide. And this will be my last slide. So what can civil society like us and media companies can do for election information and transparency? One is collaboration with COMELEC on social media monitoring because again, if COMELEC would start to monitor the social media space, there is that recognition that a lot of companies, a lot of organizations in the Philippines are already doing this for a long time already. They've been doing this since 2016 and they have the expertise. So I think there's really a need for these organizations to collaborate, to partner with COMELEC for the transfer of expertise. Because the elections are probably 295 or 290 days away from today. So if COMELEC wants to establish a social media unit, then there's a need for them to learn as fast as they can, and they can get this experience, this expertise from other civil society organizations doing fact-checking, for example. And another recommendation for CSOs and media is to push COMELEC to adopt a code of conduct to ensure election information integrity. And we've been pushing for a code of conduct for PR firms and individuals engaged in political propaganda since 2019. And I hope the AI use would be included in this code of conduct. So it's high time that we have this code of conduct for political parties and candidates when it comes to campaigning. And if you want to have a copy of that code of conduct, you can scan this QR code for your reference. So yun lang po. Marami pong salamat and magandang hapon po ulit sa ating lahat.
Attorney Ona keeps saying sorry, but really, thank you very much. She is the embodiment of the crusader against misinformation, disinformation. Why do I say that? If you noticed, her slides contained the sources of what she had been saying. So, no need to fact check, or it's easy to fact check everything she has stated because she has indicated the sources, all of them there. Plus, her presentation provided references that the COMELEC can use in crafting the framework for regulating AI, right? And it also talked about the specific proposals to COMELEC and even the recommendations that we, as members of civil society, can do in helping COMELEC. So I think we should congratulate each other for heeding COMELEC's invitation to take part in this breakout session, because by being in this breakout session, then we are collaborating with COMELEC in trying to come up with that framework to regulate artificial intelligence. And finally, but of course not the least, our very own attorney Oli Reyes.
By the way, I'll just apologize. I don't have any slides. I only was able to finally confirm my attendance this morning. I just hope that whatever I say are dynamic enough to cause any visualizations. But I just like to start by perhaps stepping back and just asking the fundamental question, which I think COMELEC and any other regulator should ask, and that is it really necessary to regulate AI, even in the use of elections? So, my own first encounter with AI-generated or AI-enhanced content when it comes to Philippine elections was some months before the 2022 elections, when my social media feed foisted on me this video that was a series of clips that were taken from the Princess Diana scenes in seasons 5 and 6 of The Crown, but with the face of Sara Duterte deep faked in every image of the Princess Diana. And this video was no talkies, just a soundtrack of some very catchy rap music, I believe, by Andrew E. So siguro, or maybe somebody younger, pero yan ang kahenerasyon ko eh. So, then tuloy-tuloy lang. And I felt compelled to watch the video through its bitter end. And I think I rewatched it 2 or 3 more times. Now, and this was at a time when she was being touted as a likely presidential, of course, ultimately vice presidential candidate. And so obviously that involved the use of deepfake, that obviously, which is what, as mentioned, one of the forms of AI that is now deeply concerning. It obviously was created in the context of a likely political campaign. So the question is, should this be banned? And of course, there was a seemingly draconian proposal at first that, well, all the use of AI in all election materials be banned. So, I mean, if you ban the use of deepfakes in that context, I mean, what's the difference between banning that and banning the use of, let's say, a live impersonator? And again, kapanahonan ko, Willie Nepomuceno, for example, appearing in a campaign video pretending to be Erap or Marcos or whoever, and saying things. Now, of course, that particular video that I saw, did it contain any content that could be said to be misleading, disinformation? Obviously, this was not Princess Diana. I don't think that there was any serious attempt to purport that this was Princess Diana or Sarah Duterte, But of course, it all helped towards A, enhancing or creating an image perhaps, and more potently, B, establishing some form of recall, visual. Essentially, I thought more of Sara Duterte after that video. And of course, that is the goal, that is the orientation of a lot of the way that political campaigns are run in the Philippines. I mean, the name recall, the visual recall, even if there are no particular messages or information or even philosophies that are associated with a particular name and image, but the fact that the image or name sticks to your head, well, that's part of the traditional template of campaigns anyway. AI would have, of course, a potentially strong effect in magnifying that recall aspect of campaigns. But just because AI is more effective in magnifying recall, would that automatically be grounds for banning the use of AI? I mean, let's assume, for example, that the use of AI towards that end is a more cost-effective way than, let's say, spending all this money to have all of these posters lined up in mga highway and barangay in order to foster recall. Perhaps it can even be said that because it's more cost-effective that way, a lesser-known candidate, one who doesn't have the financial resources to bedeck our national highways with all sorts of banners proclaiming a name, they might actually have a better shot at winning that name recall. And is that really bad? Is that really a concern that AI, when it comes to the use of AI, that should be regulated? Second example, and this is one that I encountered only just a few days ago. I saw this documentary which was produced by Channel 4 of the United Kingdom in relation to the recently conducted UK parliamentary elections, featuring the Tories, the Conservative Party, and the ultimately victorious Liberals. Labour. Now, that documentary on AI and election campaigns, it was an experiment actually. They took 20 voters, 10 Tory-leaning voters, 10 Labour-leaning voters. The Labour-leaning voters were exposed to various AI-enhanced campaign materials produced or or against the Labour candidate. The Tory-leaning voters exposed to also to AI-enhanced materials slanted against the Conservative Party. Guess what? Of the 20 voters who came into the experiment leaning one way, 18 of the 20 switched sides because of the AI-generated content. Now, what was this AI-generated content? No, it's not just merely the deep fake, the innocuous deep fakes. This time, these were deep fakes of candidates, of the leaders of the respective parties, saying false things, making false promises, saying that they would raise taxes, that they would ease immigration, saying things that catered to the fears of the the voters who were leaning towards a candidate but were somehow afraid about supporting that candidate. So obviously, AI was very effective in changing minds using disinformation. But that said, I think we should still step back. One, there still is freedom of expression. There still is freedom of expression, especially in the context of political campaigns, in the context of political speech. It is, of course, a preferred right. There, you have all of the jurisprudence to that effect. If we perhaps once thought that the regulation of content in election campaigns or oriented towards in political campaigns, there would be greater leeway, there would be less space for freedom of expression to come in as a regulatory, as a regulatory concern. I think that the decision of the Supreme Court in the Diocese of Bacolod versus Comelec case essentially clarified that no, freedom of expression still becomes a frame of reference when analyzing how the COMELEC regulates campaigns. And interestingly, in the Diocese versus COMELEC case, I would have thought, personally, that the regulation of the size of a campaign banner, which was at issue in that case, that would have been a sufficiently content-neutral regulation. But apparently the Supreme Court, although if you look at the Supreme Court decision, technically the Ponencia said that this was not actually content neutral. That even as a content neutral regulation, it fails. I think that it is clear that even regulation that is ostensibly designed as content neutral may still face quite strict scrutiny on the part of the Supreme Court. Now, AI regulation, of course, it can come two ways. One would be to flirt overtly with content regulation and say that, well, if it's disinformation, if it's untruthful. But of course, the problem there is that I think that there's always, insofar as campaigns actually deal with information, there's always been that, they've always flirted with that line. Part of the objective of political campaigns has of course been to persuade one side to vote the other, and that has always involved saying things about the other side, playing all of the semantic tricks, lawyers' tricks to try to convince that this is what the other side stands for. And of course, that is content. That is a matter of content. But if you were to regulate on that purpose, you cannot say disinformation. Well, and this perhaps, of course, lies with the problem with regulating fake news in the first place. There's whole matter of assessing what exactly is truthful and what is not, what is correct and what is not. That's all. That is just that that question as what is true or what is not. That's an existential question that has existed for thousands of years, and we're not going to solve that now through a law or regulation. Now, at the same time, there is a lot of space for a more content-neutral way to regulate the use of AI. By the way, I do have serious concerns about classifying social media as mass media in the context of the Omnibus Election Code, because that would mean that that would lend support to the idea that social media, internet platforms are mass media under the Philippine Constitution, and there's of course a nationality requirement, and that would mean bawal ang because of that nationality requirement, bawal sa Pilipinas ang Facebook, bawal ang Twitter, bawal ang YouTube, bawal ang Netflix. The only thing na pwede dito ay Viva Max. But at the same time, I would say that a content-neutral regulation that is particularly directed at platforms would, I believe, be the most constitutionally sound way to go about this. You're regulating not the campaigns, or of course, when it comes to the campaigns, I think that a labeling requirement that should pass constitutional muster. But if you are to have a labeling requirement, I would suggest that you have to control the size of the label. Because most people consume content on their cell phones. If there's just a bare labeling requirement without mentioning the size, hindi makikita yan when we consume content on our mobile phones. But I think platforms, I think regulation of platforms would be more effective than regulating the campaigns themselves. It's more constitutionally sound because it's not their speech that is being regulated. I have started to flirt with the idea that perhaps the most effective way to regulate disinformation is really regulating platforms under commercial speech doctrines. This would mean that essentially the regulation of commercial speech, especially as adopted in the United States, there is greater leeway to regulate content if the content is deemed as misleading. Commercial speech that's what you differentiate commercial speech from regular speech, in the sense that commercial speech involves, making expression with the idea of earning income. And the thing about how platforms operate here is that, they don't operate as neutral platforms for anybody to just express their views. There is an obvious bias towards generation of engagement. And that is why, that is how the campaigns, like for example, the Trump campaign, or, that's how they effectively were able to exploit platforms. The micro-targeting clearly identified undecided blocks of voters. And of course, platforms play along because, it's content, it's promoting engagement. And I believe that is a commercial purpose enough in order to, start regulating how platforms operate. And it's even best, and the thing is, of course, freedom of expression, as the old cliche goes, that's why it's protected, because we must preserve the marketplace of ideas. But at the same time, what happens if the marketplace is rigged? And I think that that would be, the fact that the way that the marketplace is rigged, that is, I think, uniquely within the ambit of how platforms operate. And I think that that would be the most viable means of regulation. So my time is up, and thank you very much.
All right. Thank you so much, Attorney Ollie. I didn't know you were such a flirt. Because you love flirting with ideas, okay? So, well, essentially, you stated that you would veer away from content regulation, very much consistent with what Attorney Ona stated earlier, right? But instead, you would recommend regulation of the platforms, correct? Okay. And so we now come to the most awaited portion of the breakout session, which is, of course, your participation, your questions. So we're now opening the forum for your questions. And unfortunately, because we do not have a wireless microphone, those who want to ask questions will have to make rampa and come all the way down and ask your questions on the podium. I can bring the microphone over to you, but then the cable is a bit short. So, who's going to be our first rampadora or rampadera? Okay. Is it okay if I ask the first question then? While you're composing your questions, or meron na? I'm seeing a hand being raised. You're not raising the question. Kanina, someone was, akala ni Ma'am Malu nag-raise ng question and ayos ng paling sweater. Well, anyway, sige, while you gather up your confidence to make ramp and ask the question, I'll ask the first question. Okay. So, Attorney Ollie said he would rather that COMELEC regulate the platforms. And he would rather that COMELEC do not focus on the content, right? Because of the primacy of freedom of information. So that's pretty specific enough, right? So looking at platforms, Facebook, TikTok. As I've said earlier, this is consistent with Attorney Ona's recommendation. So if you would recall, Attorney Ona presented several proposals. One of the proposal was there would be transparency approaches versus content regulation. Now, my question is directed towards Attorney Ona. What specific transparency approaches do you envision?
Yung disclosure on the use of AI for example, if for candidates and political parties in other jurisdiction, they're disclosing that AI was used, for example, for a particular campaign activity or campaign commercial. So disclosure on the part of the candidates and political parties. So parang self-disclosure, parang voluntary self-disclosure.
Yeah, all right. And this is also consistent with research. So in research, AI is used a whole lot also. And one of the recommendations, so as in elections, the use of AI, right, the rules with respect to the use of AI in research is also a developing thing. And the recommendation is that if a researcher is going to use AI in the research output, in the paper, there should be disclosure that AI was indeed used. So Attorney Ollie has an answer.
Now, just to add lang. So in the documentary I saw, obviously they featured some of the deep fake videos, but the broadcaster was concerned that these deep fake videos would in turn be spliced and disseminated. So what they did was when they featured the AI content, there was a watermark that was embedded. So it's just not just dito sa ilalim na dito, no way to be able to wipe away that watermark. So even if that content were to be redistributed, the watermark is there that says that this is AI generated content. And so I think that's one example of how to effectively label.
Yeah, all right. So because there can be some materials where it's not all generated versus via EI. So there'd just be a portion of that material generated via EI. So what do you think? The disclosure you talked about, Attorney Ona, should it just be a general disclosure that would say like what's indicated in your slide source and then so something like that AI was used in generating this content, or should it also contain the extent in which AI is influenced has influenced this content, this material?
I think enough na yung general disclosure because with what we're seeing in Meta is they have a general disclosure, not yung specific disclosure as to how AI was used in the content or in the material.
All right. Okay. So do we have questions? Right. So sir, please. Yes, your voice is loud enough. Perfect.
I'd like to take off from that meeting the court on the technical deceptive AI Act. And what if the intent is to malign the candidate towards the LTA election? And under the, it's enshrined under the freedom of speech, but not the freedom of lies. Where does the defamatory law apply and where does cyber libel apply in this case? I mean, there's no need for regulations because there's an existing cyber libel law. And that's defamatory in the act of that candidate. So were you going to cover the protection of the freedom of speech, are you trying to do the freedom of lies? Because it's going to be hidden by any culprit, any cheating candidate will do that.
Sige, maybe I'll start. So, cyber libel, or libel for that matter.
Technical deceptive election act as under the Philippine court.
Yeah, okay. I'll just start off by explaining what is the current state of libel, cyber libel jurisprudence here in the Philippines, and we have adopted the so-called New York Times versus Sullivan standard when it comes to political figures, political speech, and public figures. And I think that there would be no doubt that a candidate for public office would fall as a political or public figure. And that standard is quite high because in order for one to be criminally liable for or civilly liable for libel, it's not enough that they say something that is untrue, but it must be with reckless disregard for the truth, meaning that it's not just that the statement is untrue, but you made the statement without regard whether or not the matter is true or not. So I think that intentionally, okay, there's a difference I think between intentionally maligning a candidate and intentionally attributing false statements or false acts to a candidate as if they were true. Because I think just maligning a candidate saying, I don't like this idea, these ideas are terrible, these ideas are existentially threatening, I think that's all within expression, the freedom to react. But to say that this candidate did this, did that, when they did not do so, I think that could fall under because you're intentionally inventing a falsehood without regard to whether or not it might be true or not. So I think that could fall within liable prosecution even under the public figure doctrine. So, of course, the thing about cyber libel now is that's why cyber libel was increased as an increased penalty to ordinary libel. What underlies that is the understanding that it's easier to commit cyber libel. The technology has made it easier, that would justify the higher penalty. And perhaps that would also be one of the considerations now when you make you target specific tech regulation when it comes to political speech that uses these technologies. That's my intervention. Thank you.
Thank you. I agree with Professor Reyes, and my addition is that freedom of speech is tricky because it's a cherished fundamental right, And to ensure that we maintain to enjoy it, we must tolerate certain, how do I say, shades of falsehood. So it's not sufficient for a statement or a content to be false. So I think that's why our laws on libel focus on the intent, the actual malice element, as it is called in libel. And this is tricky when we carry it over to administrative enforcement, because normally in libel cases, the proper authority to determine whether there is actual malice is the court, the RTC, which has jurisdiction over libel cases, whether published libel or cyber libel. Um, can the COMELEC make a determination of actual malice? Well, I will take a page from Attorney Al's lecture earlier and adopt the liberal view and say yes. Because the COMELEC has a constitutional mandate, and in the exercise of that jurisdiction, we have what we call in law a doctrine of necessary implication. When a government agency is conferred with certain powers, that carries with it all of the necessary powers to carry into effect that power. So as mentioned by Attorney Agra earlier, COMELEC has the power to ensure CHOPFE elections. All necessary powers to carry that into effect is included, which in my opinion includes at least a determination whether or not actual malice is present, so as to make a determination, not for criminal liability per se, but at least to order a takedown or make a request to social media to cause the takedown of the violating deepfake or content. Thank you.
If I may highlight one thing, there's a technical definition of what campaigning is. Campaigning is positive and negative. Vote for you, don't vote for him. No? And so promoting the election or defeat. So misinformation can fall under legitimate campaign. Meaning the reason why I'm engaging in deepfake, but I suppose no one will admit that, is because they want to cause the defeat of that particular candidate. So it's very difficult. My point is, it's very difficult. A lot of shade, a lot of gray area. Is it libelous or is it allowable campaign?
Yeah.
So that's the tricky part.
Right. How about Attorney Ona? Would you have some input? Right. Okay. So that's really interesting. So as what Attorney Darwin stated, when it comes to libel, there are, there are certain shades of a falsehood that we should tolerate. When it comes to elections, all the more if you're the dreamer, if you're the candidate, you'd have to tolerate a whole lot more.
If I may, one of the things that I remembered in law school, well, matagal na yon, was, and then, when I was a student in law, one professor, my election law professor said, during campaign period, the rules on libel is not strictly followed because of that provision regarding negative campaigning. So again,
Right. So the freedom of lies during election would be great.
but there are no absolutes again.
Yeah.
Not all lies can. Well, thank you. Yes. Well, like any other technology, it can be for the good or bad or evil. But again, the difficult challenge would be
Yeah.
the one in the middle.
Right. That sweet spot, right? As mentioned by
Yes.
Attorney Darwin earlier. And that's why we're here, right? To somehow find that sweet spot that COMELEC can enforce in order to prevent AI from abusing. Okay, any more questions? I think I saw some hands raised earlier. Yes, sir. What's your question? If your voice is loud enough, then you may go ahead and ask the question right there. Okay, perfect. So you may come down and ask your question here.
Good afternoon, panels, esteemed colleagues in the legal profession. Sorry. Um, what I have noticed in our discussion is the real challenge is this the quantum of proof, since these are deep fakes, these are generated contents. The quantum of proof, or to be specific, the burden of evidence in prosecuting the claims for like for this using the misuse of artificial intelligence. If we, I'm pretty sure a few of us are aware during if you remember the Kyle Rittenhouse trial, that is a shooting incident in United States. In the trial, it was this because one of the pieces of evidence introduced there is a video, so it's somehow related to deepfakes. The circuit judge there has ruled that in order to the quantum of a proof to establish that this is indeed a deepfake is that the prosecution or either the defense should preserve such exhibit in its virginal state. So, but that will be, I believe that will be the what is that? We need what is where it may be the possible steps to preserve such exhibit.
Digital forensics.
Digital forensics.
Yung keeping the metadata of that content, and I think that would also require, okay, because actually this is a problem not just with AI, I mean, with AI, with this topic, but it's of digital evidence in general. And I think that AI is hopefully starting to convince enough judges that they should not just rely on screenshots.
True.
Uh,
I experienced.
Yeah, so, and I think that we will eventually be towards the end wherein, and I hope that our rules on evidence would specifically accommodate this, it's really metadata. Because as you say, to ensure that the content is in an altered,
An altered,
virginal state, so to speak, you really need to rely on the metadata. But that would, of course, mean that adjudicators, including administrative adjudicators if need be, they must be trained to understand what metadata is, to have enough curiosity to actually search for the metadata and inspect the metadata. So, yeah.
That's true, sir.
All right, perfect. So apparently, our topic is so interesting that we're still having our question and answer, and the two other breakout sessions have finished. Right. So, do we have more questions? Yes, ma'am. Go ahead and ask your question. So that question is posed to all of our speakers, right? Yeah. Or both. So who wants to go first? The Master Yoda?
Well, it's clear that it should be the victim. Uh, Again, the question is, can COMELEC do something about it? Again, whether you do something or don't do something, you're always. So if I were in your place, maybe, not do anything. I mean, um, hear out the complaint if there's any complaint. But I don't think you should prosecute without any complaint. I don't think you should disqualify if ever without any complaint. So there must be a complaint first, there must be a victim first, and there will be appropriate remedies. I understand COMELEC will enter into agreements hopefully with the platforms. So platforms will have to take initiative as well. But COMELEC, to be fair, uh, could also check whether the actions taken by the platforms are fair, legal, or based on the agreements entered, so that there's a form of check and balance as well as to what the platforms can do. Because the platforms can also help and also abuse their authority. So very clear for these platforms and COMELEC to have clear guidelines. When in doubt, not put down maybe. I don't, if that's my view. Thank you.
That is a very difficult question. And yes, if there is doubt, definitely um, the adage is uh, rule in favor of freedom of speech. So and more speech begets more bad speech. But um, in an appropriate case, definitely the COMELEC can take action. And in the agreements that other jurisdictions are having, so the platforms enter into arrangements with authorities. Under that MOA, um, the 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 platforms can be made contractually bound to comply with the takedown order. So, and in my view, I think that mitigates the risk of the COMELEC because there's also like a second. Well, first it will be a bit ministerial on the part of the platform, but in if the finding is based on evidence and um, I think correct me if I'm wrong, in administrative proceedings the standard of evidence substantial evidence. So um, and to as there is a high standard of review on actions by the COMELEC under Rule 63, I believe, of the Rules of Court, grave abuse of discretion. So, so I think the COMELEC can take action so long as they do not cross the line of grave abuse of discretion. Thank you.
Yung, of course, I will take the stand that COMELEC can't do anything about that because it would be perceived as partisan on your part. But in other jurisdictions, because candidates sometimes they don't have access to platforms, maybe COMELEC can provide that lane to connect the candidates with the online platforms. And in other jurisdiction, when we're talking about technology facilitated gender-based violence, there are other jurisdictions that are really providing accommodation to women candidates when it comes to gender-based violence. So I think that's one of the avenues that COMELEC could explore. Not intervene, but just provide the lane or the expressway for candidates to connect with the different online platforms.
Yes. Yeah. They're in the, yes, yes.
Yeah. Um, just to add, I do think that if the Commission wants to be proactive, especially in regulating the content that is coming out of the campaigns themselves, they would be really treading on dangerous ground if it's content-based. So like, for example, saying that it's maligning the candidate, anything that would require some, essentially interrogation or investigation into the substantive truth of what is being said, that's going to be difficult to, COMELEC will of course be opened up to charges of partisanship. I think that it would be on safer ground, the Commission would be on safer ground if it were a content-neutral regulation. As long as, of course, anybody who, when I mean by content-neutral, for example, failure to disclose whether, who's the funder of the ad, whether or not AI was used, if indeed such a rule were to come out, nothing to do with the, or as much as possible, nothing to do with the content. But of course, content-neutral, violation of a content-neutral regulation, of course, has to also be enforced even-handedly. I mean, it's enforced if the PROMELEC were indeed to be proactive. Anybody who violates the content-neutral regulation should be proceeded against in order to shield the Commission against charges of any undue bias or partisanship.
Perfect. Yeah. So thank you so much, speakers, for your answers. So what's emerging as a, common recommendation here is number one, COMELEC should veer away from content regulation as much as possible because it can be tricky, primarily because of freedom of expression. And the other thing that has been consistently stated by our speakers is more on the platform-centric regulation, or maybe regulation can be a strong word, collaboration, right? So we have 5 minutes more. Can we accept one more question, or should we? Okay. So one last question. Who will ask the final question? Wala na? You're happy with the discussion so far? So, last chance. Baka may hindi makatulog dyan. Pagdating sa bahay, sana tinanong ko na lang, right? So, if there are no more questions, then thank you so much. And before you go, the COMELEC and of course the UP College of Law would very much appreciate it if you would give your feedback on, this isn't just for the breakout session, right? It's for the entire forum, right? So kindly provide your feedback by scanning this QR code. And then, again, thank you so much. Thank you to our speakers. Thank you to our participants for your questions as well, and to our COMELEC personnel.
Selection.